Hey, good morning, everybody. It's Ryan and Grant for another episode of Grant Teach Something. Today we've got Scott Horne in here, and who is an attorney. So if you have questions that are all attorney law stuff, today is the day to jump in the comment section to pick this man's brain for free versus calling him up for a $3,000 a minute charge. Anyway, stick around, ask questions. We're looking forward to this, and we'll see you right back.
Teach me something.
Yes. Yeah, we'll do that for sure.
That's the cue.
That's the cue. I'm looking at the street. What's up, guys? Hey, it's Grant here. Yeah.
Just so you know, for future reference, if I ever do this, that's the cue.
That's the cue.
That's the cue.
Okay, fair enough. All right, guys, it's good to have you guys here. I'm super honored. I'm super happy to have Mr. Scott Horne on with us this morning. You hear us like every episode. We are not attorneys. We are not CPAs. We are not this. This guy's actually an attorney. This guy's actually the preeminent attorney in Texas for seller financing, and this guy is the entire reason that I get to sit here today, because without what this man did in my life, I would not know anything about Subject 2 and all the wonderful creative strategies that you guys are learning on a weekly basis. So, without further ado, I just want to introduce you, Scott Horne. Thank you for being here this morning.
Well, thank you. It's going to be fun today.
The studio audience goes, rah,
Rah! Yeah, I was thinking that
I
we
hear
needed to
him.
have like an applause track here. So one thing that we do want to clarify, right? Because he is an attorney, and like we said, hey, I'm not an attorney usually. Well, there's still attorney disclosures. One of which being, does this construe legal advice?
Absolutely not. This is for educational purposes only at this point in time.
Entertainment only. So if you want some like real advice, some real legitimate, let's look at your situation and get that, then you need to reach out to an attorney. You need to reach out to somebody like Scott. But today, we're just going to be kind of going back and forth and talking about a lot of the issues that we hear questions about, and talking about a lot of what is this business, what happens out here, how do these things work. So, like you said, if you have questions, please put them in the comments and we'll hammer those out. But real quick, can you tell us a little bit about your history? Like how long have you been doing this? How many deals have you done? That kind of stuff. Let's brag about you for a minute.
Oh boy, don't really like doing that too much, but I have the.
So you're going to start off lying to us?
Well, that's what lawyers do, is it not? That's where we're paid to do that.
Is it lying or is it manipulating?
It's puffery.
Puffery.
Puffery is a good word for it.
Okay.
No, I've been around the block once or twice, guys. Y'all know that. I've been fortunate to do multiple thousands of acquisitions of properties with cash. We've done thousands and thousands of asset-based loans. We've done tax lending. You know, in our offices, we're real estate and title attorneys. I've had the opportunity to close over 10,000 creative transactions, and of course, as the law changes, it changes how you do these, from what used to be the contract for deed mechanisms that we could utilize, to the lease options, to the lease purchases and other variations, to today where it's so complicated to do that and so risky under the Texas Property Code. It's much better to go ahead and do a full owner finance type transaction where title is transferred, just to eliminate all those negative issues.
And go ahead.
Well, I was going to say, immediately when I pick up on you saying all that, one of the quick questions I would have is you talked about the transitioning, how laws change, and how, like, what's the timeline on that? Is it like a hard stop, the law is this? Like, how quickly do lawyers pick up and pufferize that new law? And I don't know, you know what I'm trying to say though, right? Because obviously there's always loopholes, there's always types, I don't want to say get around it, but just adapting and overcoming whatever that law is set out to do.
Creative navigations within the law.
Like what's the process? Is it an overnight, you stay up all night like back in college days? Or is there like a 3-month, okay, let's figure out what they're trying to do here?
No, I mean, so for instance, in 2001, they pretty much killed the contract for deed for owner-occupied properties.
And real quick, can you explain what contract for deed is to everybody?
A contract for deed is an equitable
pitch.
conveyance of ownership where they don't get full legal title, but they have equitable title under a contract. Basically, when you make all the payments under this contract, then the property owner is supposed to then give you the deed to the house.
So in essence, instead of doing like, hey, I'm going to give you a 30-year mortgage, it is, hey, you're going to pay me for 30 years, and at the end of that, if you've paid me for 30 years, then I'll give you title.
It's a great, or was a great tool for the investor, the homeowner, not so much for the prospective buyer out there, the consumer. But they changed the laws in 01, they did it again in 05 and 07, tweaked again in 09. And we get a little bit of heads up on this. You got to watch what's going on through the state and through the legislative bill procedure out there. And a lot of people in the real estate community, of course, they get this information in. We all try to share it out there. And sometimes you get a chance to go down to Austin to try to tweak what they're trying to do. I have found that they don't want to listen to one voice, though.
Right.
They are trying to protect one individual who had a problem. For instance, in the seller finance world, this last legislative session, I think there was one person out of El Paso, from what I understand, that was creating problems. And that particular representative for his district got all hot and bothered about it and was trying to change the owner finance laws, making everybody have to be licensed as a residential mortgage loan originator to do any type of transaction. And it's a knee-jerk reaction type of thing. So sometimes we get a little heads up on that, where you can go down, and/or groups can go down and try to talk with the legislatures to try and navigate things more appropriately. And sometimes it just pops up and you don't know it's there.
Can we hop in real quick and just use this as an opportunity to, like Scott's mentioning here, there is, so whether we like it or not, how do rules change in Washington? How do rules change in Austin?
Yeah, before you ask that question, I just do want to give a quick shout out to Mitch Steven and the Texas 100.
That's where I'm going with this. Thank you. Thank you for ruining I'm just laying, same page here. So changes occur in Austin and Washington, whether we like it or not, through lobbyists, right? I mean, that's the way that it works. And to your point, Mitch Steven, Eddie Speed, a bunch of us in the industry have contributed to what is called the Texas 100, which we're looking for more investors who are interested in making sure that these laws do not overtake us. Contract for deed used to be an excellent way of doing things. You did a lot of contract for deeds when that was legal, right? That's an excellent way for the investor. But because there's a couple of yahoos, everything got ruined for all of us. And we have to prevent that from happening in the future, just like this last legislative event. So if you're interested in helping out, we're looking for more people. We're looking for 100 people to commit to $1,000 for the next 3 years. That's it, $1,000 a year. And that will pay for the lobbyists that protect you. That is the reason why this legislation did not go through, was the Texas 100 and the Seller Finance, or is it Seller Finance Coalition?
It's the Seller Finance Coalition.
Seller Finance Coalition is the national version that goes to Washington. The Texas 100 is dealing with Texas. So we've got both aspects. If you're interested in that, please PM me. I can get you hooked up with all the right people to move that forward. But
and then because we do have a national audience, if you are somewhere else, please drop in the comments, whether it be YouTube or Facebook or podcast, or I don't know how that works.
And the Seller Finance Coalition is there to help national.
Yeah, just keep that in mind.
One thing, guys, I always tell people when I'm trying to put on seminars and whatnot, it's like back when we had a group called TexREA, where we were trying to pass the lease or contest the lease option law changes that went into effect, and you're trying to raise money, and it's like herding cats in the investment community because there's no licensing out there. Unlike realtors who are licensed to have a defined number you can get to them, you can't necessarily get to investors and who they are. And now that there's actually the Seller Finance Coalition, and granted that's the national organization, to have a voice like that who could come into a Texas marketplace or another state marketplace and put their weight behind these issues as they do crop up, you need to do that. And what I always like to tell investors is if you sit back and do nothing, they are going to take away more and more of our rights and erode them. And you got to be proactive to do this. And the problem is too few people want to do it. And guys, you can join for as little as $25.
Yeah.
You know, and everything goes to paying these lobbyists. These guys are expensive, and it takes someone who knows how to navigate the issues in Austin. Guys like us, we're lost sheep out there. And so any way we can do that, it's not expensive, and maybe it may not necessarily be for seller financing per se. It could be for something completely different out there. Maybe they have to, if you want to be a landlord, they could require you to have a license to be a landlord even at some point in time.
Well, even mentioning, like you've mentioned, I really appreciate how you point out that essentially a lot of these things that the cities are doing with us on landlording even, they're just figuring out ways to tax us more.
That's all it is.
Right? And without protections in Washington, without protections in our state capitals, we're not going to be able to get through that, right? So please reach out. Seller Finance Coalition says seller finance in it, but it really is just an investors protection lobby group for the national side, Texas 100 for the state side. So going back to your personal experience, we've got tens of thousands of deals under your belt that you've gotten done. In phenomenally creative manners, right? Some of the coolest stuff. Can you think of an example of one of your like shining moments of creativity that you might point out as a story of something that really required thought and process, and something that was like, oh, this is a creative navigation of within the means of the law to get things done? I know I'm putting you on the spot by asking that question after you've done so many deals, but
I think, Grant, there's many out there. I think really it's understanding the probate process sometime and trying to learn how to navigate multiple heirs who have issues.
undivided interest kind of stuff.
Where maybe you have 5 heirs, you can get 4 to sign off on something, but all 5 won't do it.
It's a great example.
I've had to buy properties. Unfortunately, you don't do that through a creative technique. It's going to be through cash, most likely. But you can do what's called a partitioning action, where you can force the sale of the property. It requires a court action and an appointment of a receiver who's typically a realtor. But it allows you to sell the house, and then of course, if you control the majority interest and you buy it back yourself, which is the ultimate goal in that regard, the net proceeds come back to you, not anybody else. Just did one of those where I had to fly to New Orleans twice to hunt down heirs, and literally go hotel to hotel to hotel to hotel to find one heir.
Wow.
Now, was this Scott Horne that did it, or somebody on your team that was doing that?
This was me.
If anybody knows
Is
Scott
it because
Horne,
it was
we
New
know Scott
Orleans,
Horne.
or
It was
He
New
just
Orleans.
was in the hotel just knocking on doors like, pardon me.
No, we knew that this young lady was worked for a hotel, she was a beautician for somebody in that regard.
Gotcha. Well, I'm
And-
glad that that's the profession that you were looking for in that hotel.
Absolutely.
Oh my God!
But
Now we know why Scott Horne had to drive it.
it's taking that effort to do it. And by doing that, we were able to gain 93% interest in this one property finally. And we had one heir who was rogue, who just wouldn't talk to us. We found him in Baton Rouge, actually.
Wow.
Knocked on his door to have him sign a deed, willing to pay cash, just said no.
How big of a deal are we talking about? Because I know time is money, and I know you have a lot of deals and you've done a lot of experience. But it's like, are we talking about a $10 million deal? Like, what level of deal is getting you to go to New Orleans?
It was about $250,000, a little bit less.
I would go to, I would. That's worth a day or two.
Yeah, and it wasn't.
And it's a business trip to New Orleans.
Yeah,
what net
Expensed
profit?
out.
And a little bit of gambling here and there. Hey, a little bit of good food. Come on, but we were successful in doing that. But it took that effort to do that. So that
Right.
was one of the creative ways to do it.
I love that you bring this example up, because this is actually one of those things that I get asked commonly enough, and I always say, just go ask Scott, because it's a tricky scenario, right? When you have multiple heirs and they don't agree. So let me ask you this. At what point is that line of demarcation? So we've got 2 heirs, one's willing to sign, one's not. You can't really do anything about that because they've got 50% interest both, right?
You can still buy 50%, you become a tenant in common.
Okay.
And then from there, you start to navigate the process of sale of the property. For instance, if we're brothers by different mothers and we inherit a property together, and I want to sell and you don't, it's not fair that I'm stuck doing it. You can buy me out, I can buy you out, or we can sell it to a third party. But one heir cannot hold the other hostage in that scenario.
Okay.
And that's why some things are out there in that regard, and a lot of people don't know you can do that. Now,
I think
does
that
cost
this is
money.
our golden nugget of the episode, by the way. This is going to be the something that all of you can take away from, because this is a phenomenal way to get into properties that other investors are having to say no to, right? I mean, how many times do you run into an undivided interest sale where somebody else has already looked and said they can't make it happen?
Well, it's quite a bit, but the problem is with so many investors out there, this process oftentimes becomes cash intensive because you've got to pay cash. You can't get a loan
Right.
through an asset-based lender or a bank or private lending in that regard, and so it becomes cash intensive. And so it's not that people don't want to do it; they simply can't do it because of all the processes involved.
Cool.
But again, it's a recognition factor.
Yeah.
And there are other things that you can do. I know we talked a lot about how you navigate liens out there. It's an understanding of the lien process and what can and cannot be removed. And again, there's just, most investors, again, don't have the ability to remove it. They don't have the legal knowledge to do it.
Right.
That's an empowerment that, I get the ability to handle sometimes. And we try to do that for our investors out there as well.
Speaking of knowledge, real quick, because now that you're here, I can ask you on camera, because this is the answer I give to everybody all the time. Because they're like, how do you do this? How do you do that? I'm like, I don't know. I don't need to know. Get somebody like a Scott on your team that will just know it for you. Like, is that the wrong way? Or, I mean, obviously you have, like, when it comes to owner finance, seller finance, like sub-2 type deals, there is a baseline type of knowledge, but overall, if I'm working with a Scott Horne or whoever, and I've got your contract, it's pretty much straightforward. But the reason I have someone like you on my team is so I don't have to know all that. Is that a small-minded, ignorant way to look at it, or is that effectively okay?
No, I think, Ryan, with that scenario, I could work 48 hours a day with a number of people who call me who simply want to pick my brain and ask questions.
Right.
And you can't do it. It's impossible. And, if we're handling the transaction, the closing for somebody, I always like to tell people that we're the closing attorney. We're not their actual attorney, per se. We don't represent the seller or the buyer. And the problem with that is no one wants to pay the additional legal fees for representation, as we'd call it.
Right.
And so oftentimes we steer them back to their mentor, whoever that might be, to try to get questions answered. Otherwise, we just spin our wheels all day long answering questions for people out there.
I think that's Scott's way of saying, don't tell them to call me.
But, if
Hello,
we're handling,
Grant, not me.
I had a call just yesterday evening where the guy was closing a property and the seller died 2 days before closing.
Ouch.
And it's like, what do you do? And it's like, because his title office says, we can't do anything to help you. And I said, guys, before I can help, you got to transfer the deal over here. No, I can't do it for free. I do have creative ways to handle a deal like that. So if for some reason our underwriter just won't do it because of some legalities that may be there, I was able to afford him other options on how to get the transaction closed for his seller and his back-end buyer both. But it's got to come in first. I can't just say, well, go do X, Y, and Z and do it. But if we're handling the transaction for him through a title perspective or through the legal closing perspective, then we put our firepower behind that deal to try to make it work for him.
And I think that point is very important to hit, in that one of the biggest selling points that you'll hear me say consistently is that if a deal can be closed, I mean, this is why I've worked with Scott for so long. If a deal can be closed, Scott's going to be the guy that can figure that out. But guys, as an audience, as somebody, as a client, we need to be respectful of that knowledge and of that time, right? And that knowledge and that experience and that time does come with a cost. And don't be afraid of that. And I want to, full disclosure here. Like I said, it mentioned at the beginning, Scott and I were partners for 6 years, and recently split within this last 6 months or so, amicably.
On
Terrible terms. So I do want to point out, yes, we were partners. No, I don't get any kind of financial gain from any kind of referrals or anything like that. This is not a sales pitch. This is purely somebody in the industry telling you how to get things done that need to get done. I run into so many times where somebody, I'll say they've got some crazy sub-2 deal, they've got some crazy airship deal, they've got some crazy lien or IRS this or whatever that, and I say, well, go see Scott. Yeah. And they're like, well, but I've got this attorney that'll only charge $350 for the closing. And I'm like, yeah, that attorney probably sucks. Probably doesn't know how to get it closed right? You may have to pay a little bit more. He's not going to be the most expensive guy out there by any means, but it's not going to be the cheapest guy, but you get what you pay for. And don't be afraid of an extra $500 when it means you're going to make 10 grand on a deal.
Yeah, and just so, this episode with us, this is very dialogue-y. Is that the word? Whatever,
yeah,
it is now. So if you have questions, drop them in there. Otherwise, it's just going to be three old friends just shooting the crap about, hey, how's A&M doing this year in football?
Let's go on to the next conversation.
Right. I mean, so we need your help to get these questions in. And again, one thing that was funny several months ago, and I forget the situation, but I do remember like Daniel and I being annoyed because we were helping somebody out, and we weren't annoyed that we were helping somebody out, but it was just like we have Scott Horne on the phone, like that's hard to get.
Right.
Like even as a friend of Scott, it's hard to get him on the phone. Stop wasting it by like just like I don't know if you remember the situation. It's all coming to my head now, but this person was just like it's like you need to be quiet and let the man speak. But anyway,
Yeah,
if you
listening. We talk about negotiating and listening being such an important skill. When you've got somebody on the hook that has the kind of experience like he does, there's very few in there. I mean, I could probably count on one hand how many people have this type of experience. So please take advantage of that in the comments and ask the questions. Here's a good question. At what point in time in your investment career do you need to get an attorney on your team?
Ooh, good question, Jessica.
Besides
Thanks,
day
Jessica.
one. You know, the key is you don't have to have a lawyer to be an investor. That's really the main thing. It's nice to know someone who you can call. So often, like in our industry, people think they can go to a title company and that title company is going to afford them some type of legal advice. I see transactions all the time that have stalled because the escrow agent failed to get a lien released at closing. In fact, just the other day, for an instance, there was a title company over in East Dallas who actually brought the seller of the property in, closed the deal, but there was a judgment lien that had not been released yet, and they were waiting on it.
And that's bad, right?
Look, they ain't gonna close. And had they done
That's
the
my
proper
role at this. All this is just do stupid.
and had they
That's
done
more,
the proper
right?
steps 30 days before, they could have done it. But why did they waste everybody's time?
Yeah.
We had to pull back, refund the money. They came to us. We had to put all the paperwork in place to make that happen. Wait 33 days, and then we got them closed. But you see that out there sometimes. And what you don't have to have the lawyer to close. That's just the bottom line. To close a seller finance deal, yeah, you do. But realize that title companies don't close these transactions. They do not know how to do it. They cannot draft the paperwork. And as you always hear me say, guys, you know, in our industry, a trained monkey can draft
Note and deed of trust.
your standard legal documents. The most important part of this business are disclosures and the knowledge base and the explanations to sellers and buyers.
And the experience to know why people are suing, so you know what kind of things need to go in disclosures ahead of time and that kind of stuff.
And on that note about the trained monkey aspect of it is a lot of the stuff we just don't know because you're ignorant and you just go with the flow of what you're supposed to do. For years, the previous organization I was with, we would get a memorandum of contract, and I think we would pay the title $300 to do that. I get over here with Daniel, and Daniel's like, it's like $30. Why aren't you just doing it yourself? And the thought process of doing it yourself, like until somebody like gives you permission to do it yourself, like I would never, I would just assume that that's a title thing, pay them $300 and they can take care of it. Move on.
You know, I also find it kind of funny, just going back to the attorney issue and whatnot, you can always tell when there's been a seminar ongoing because my phones blow up, because everybody, they think that the secret is you have to have this super special team on your side of advisors on every deal you do. And you don't. You know, we try to go back and tell these people, it's like, that's great, we're here to help you at the time, but you got to get your first deal first.
Well, and that's such an important part, and we're going to go to break here in just a second and then come back and kind of hammer out more of these topics, but that's such an important thing to leave on with a note right now, is that nothing, absolutely nothing replaces action. Okay? Too many times, I have meals with people and they show me all these spreadsheets that they've created, and they tell me all about these models that they have. They're going to make so much money, and they've spent the last 3 months creating this model that works for. How many houses have you bought? How many times have you actually sat in front of a seller and had them sign a
Offers.
contract?
Yeah,
you don't need that crap. You don't need to have your attorney and your blah 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 and your CPA and all that kind of stuff to start talking to sellers. You need to talk to sellers. That is the most important thing.
On that note, I remember many years ago at one of the other events, and we had a bus tour, and then like 6 or 7 months later, somebody came in, Ryan, I'm so excited. Thank you so much for da-da-da-da. Man, I went to my first house and made an offer. Okay, how'd it go? Oh, I don't know. What do you mean? I'm like, did you follow up? Like, well, no. Well, so you wasted your time to go there. And anyway, you wasted your time to go there. You wasted their time. You made an offer, but you didn't follow up. And it's just like, well, I really don't have the money to buy it right now. And I'm like, it breaks your heart because you're like, what are you doing?
I mean, I just want to use an example about that again. There was a home that, I got two. I got one going on right now, but one we bought previously where we had mother died, father died, there were 4 brothers and sisters, one died, and you couldn't find anybody. And the house is going to foreclosure by the city for taxes and other issues that were unpaid. And you had to go out and hunt people down. We found the wife of the deceased person who then put us in contact with somebody else. No, I had to drive out to Roy City to meet one of the heirs, got thrown off the property at that point in time. That always makes you feel good.
Now, is this for your own personal investments or somebody else's?
This is one of ours.
Okay.
And then had to drive to Sherman, and we get to the house where we think the people live, and no one's home. So we leave a note in the front door. We drive off, go to Dairy Queen, do whatever we did, worked a little bit, came back, happened to catch them. But by taking those kind of efforts and not sitting back and just making a few phone calls and they don't call back and stopping, it's being proactive to really get out there and do this stuff. Now, you can't do that on every deal. It has to be reasonable. You can't drive to Timbuktu all the time. But going to Sherman for an afternoon for that purpose is worth it. And it's making that effort. I have a home right now where both, it's a divorce scenario. It's a foreclosure in December coming down. Great house. Husband and wife aren't talking to each other right now. Cell phones aren't working, not taking messages. What do? I intend to go camp on their front porch and at least get one of them today or tomorrow in that regard and find the mechanism to get number 2. Whatever that might be, we will go to their home, knock on their door, and talk to them.
And you guys should be appreciating the fact that we have a man here who's been an attorney who's been investing for 35 years.
I'm not that old.
And he's still driving around and grinding and knocking on doors and making deals happen. This is not somebody you do. So many times we see the gurus and we see the educators that are like, oh, you can invest remotely and you never have to touch a thing and all you do is make money. You run a Facebook ad and you'll just make millions of dollars. And that's not the see, that's not the reality of the business. The reality of the business is you have to work your ass off. I think me and Ryan talk about the days. Sorry, thank you for correcting me. Ryan and I talk about the days where back in the office where we met. Well, Scott was the owner of that building. The only people that would be there after 6 were the 3 of us, and Scott is out working all of it. And Scott has more money than you can shake. The dude is wealthy. He's working till 9 at night every night to make these things work.
I have money trees in the backyard, don't y'all?
So let's take a break real quick.
Yeah, I was gonna say let's stop stroking all of our egos.
Well, no, I'm just saying, I'm not trying to stroke ego. I'm trying to point out that you can't stop. You can't let up.
That's a good point. But yeah, we are gonna take a break. Looks like we've got some really good questions coming down the pipeline. So hopefully your brain has warmed up a bit. Up a bit. Did I say it right?
No.
Up a bit. Warmed up.
It's so cold in here. It's freezing up your jaws.
The AC makes it hard to hear. So looks like we've got some Dodd-Frank questions, Laura Lee questions. So I hope you're ready. Stick around. We'll be right back and keep those questions coming.
I'm like looking, which one of us do it? All right, welcome back, guys. So we're going to hit some of these questions. We've got some really good questions coming in. I hope you've been thinking of more because this is a very unique opportunity that you're going to have to be able to get some of the more complicated, some of your more legal questions taken care of. One question comes in from Chris Ontiveros. Has Dodd-Frank been rolled back or are those rules still in place? What is the best way to buy these days, subject to or lease purchase? So let's take this in 2 different chunks.
And keep in mind, Cashflow Chris is out of Phoenix, Arizona. So
right. I was going to bring up the national aspect.
Yeah.
So Dodd-Frank being rolled back. Can you? People say Dodd-Frank's being rolled back or has been rolled back. What's happened?
You know, from what I understand, and again, I'm not the definitive expert on Dodd-Frank per se, but they did roll it back a little bit for the big banks, I understand, which has nothing to do with us.
Absolutely.
No, I still believe that all the issues that Dodd-Frank pertains to regarding us small creditors and whatnot, so for pretty much everybody out there, is still in play.
Right. So if you've done fewer than 2,000 first lien transactions in the previous calendar year, and you have less than $2 billion with a B in assets, you're a small creditor. The Dodd-Frank changes that occurred only affected about 5 banks. It went from changing regulations from like 8 banks qualified to it to where now like 3 banks qualify for it. So that's what happened in Dodd-Frank. Our world is exactly the same. So let's move on to the lease option versus subject to. Now, this is a great topic because we do have a national audience. We do have people in other states, and in other states where lease options and contract for deeds are available.
Can we define lease option?
Yes, absolutely.
Love that, guys.
There you go.
Well, so first off, understand what an option is. An option is simply that. It is the right to purchase a property for a particular price, maybe with particular terms, at some time in the future. And of course, the problem is here in Texas, we are limited regarding the sale of real estate. That's going to be a homestead for somebody. If it's non-homestead, Wild West, do what you want to do. But for a homestead property,
well, and even let's clarify there, it's not even necessarily homestead classification as much as it is owner occupied, right?
well, yeah, same thing.
Right, but they could forget to file their homestead, and it's still classified. As long as the person you're selling it to is going to live in that property, it's the homestead that he's referring
Yeah, well,
to.
keep in mind, I get this question a lot, by the way.
Okay.
Well, they say, well, they haven't filed their homestead exemption, so it's not a homestead. If you live in a property, it's going to be classified as your homestead here in Texas, period. So, owner-occupied, if it's your homestead, whatever it might be, the problem is we have a 6-month window, and if you exceed that, you must convey ownership to that person. So you want to avoid that in all cases. Now, in other states, and by the way, in most other states, probably, the contract for deed, executory contract is in play. I'm sure that lease options are in play. And because we border Mexico, a lot of this stuff came in to works. For instance, in Arizona, it also borders Mexico. It may or may not have some of the same issues like that are out there. I don't know. I'm not a lawyer in that state. So, of course, if you're in these states,
Get state,
you want to
local
check those kind of
attorneys.
items out and ensure that they're accurate.
So the option, if you have the option as a seller to choose contract for deed / lease option, which are 2 different things, but kind of qualify as the same in my opinion, versus a sub, well, actually, it's funny he asked versus sub 2. That would actually not be. We're talking disposition, so that would be like a wraparound mortgage or an owner financed mortgage. Sub 2 is more of your acquisition side. But if you have the option of doing an owner financed transaction with your buyer or doing a lease option / contract for deed, if you don't mind me lumping those 2 together, what's your choice?
I think it depends what you're trying to accomplish. Most people like to use a lease with an option to buy to give the buyer a chance to get financing to cash them out. And they need to have time to either accumulate their down payment, funds, whatever it might be. With a contract for deed, you're basically selling the home right then and there. And from there, the question becomes, what is your long-term role? If it is to hold on to that property long-term and not worry about things, and you have the ability to do a contract for deed and your state's laws aren't too onerous regarding that, go with it.
Do you happen to know any states offhand that, I mean, I know the majority of the states actually allow the contract for deed, right? It's mainly Texas and maybe 2 or 3 other states that don't, am I right? I'm not super nationally.
But different laws change in different
Yeah, that's
places,
true.
though. You know, here in Texas, for instance, if you had a contract for deed and they've made more than 48 payments, you're going through a foreclosure process just like a mortgage. And what I was trying to get at is sometimes people who sell homes, they may want to sell that property with the intent to sell that mortgage or that contract for deed down the road in the future. Well, most mortgage buyers are going to want to buy a mortgage, not buy a contract for deed, per
That's a
se.
very good
because the
point to
laws
bring
are
up.
going to be more regulated, I think, and more protection in that regard.
Now, if you're going to do a contract for deed, maybe I'm throwing a curveball because I actually don't know the answer to this. I think I do, but I'm going to ask you. If you're going to do a contract for deed, do you still need to go through the full RMLO Dodd-Frank qualification process?
Can I just make this up as we go
Sure,
also?
why not?
No.
It's for entertainment purposes
This is
only.
legal advice that you can take to the bank and use. I'm just kidding. This is not legal advice to you, but but what's your thoughts on
I
on
would
that?
think any time, regardless of the scenario, that a buyer is going to be living in that home, as an owner-occupant, I think you should go through the standardized processing every single time.
And you know what? I say this, and you're answering that, and as I'm thinking about it, I'm thinking about the laws, and you're right. What Dodd-Frank qualifies as needing a RMLO to process is called a quote-unquote federally related mortgage. A federally related mortgage is any time that you are negotiating credit to somebody to live in a house. Right? They made it very broad intentionally to catch situations like this. So if we can powwow that answer together. Yes, you need to do that still. So if you have that option though, with the lease options and stuff, those are great ways to go. So great question on that one. Thank you for answering
Just
that.
throw one more thing in there too for us, Grant. So sometimes you see investors who put properties into land trusts of some
Yes,
type.
I wanted to get to that today.
And so, of course, they may transfer the beneficial interest of that land trust from themselves to their home buyer in some regard. And their philosophy is, well, we're not selling the property, we're selling the trust. And my response is, no.
Because you're negotiating credit for somebody to live in that house, therefore it is a federally related mortgage, therefore it is qualified by Dodd-Frank. But I also want to bring up, I'm really glad that you brought this, so I'm going to skip, I'm going to push a question in there myself that I know people have questions about. I heard, see, I had this guy come through, he's from another state, he's brilliant, and he charged me $25,000 to go to a 2-day event, and he told me that if I put my property into a land trust whenever I'm buying it sub 2, that they can't call the due on sale clause on me. Isn't that cool?
That is cool.
Yeah.
I don't think that's true, though.
Oh, really?
Really? Imagine that.
Can you tell us a little bit about that? I hear this crap all the time. Here's the thing. People don't understand trusts, flat out. I guarantee 95% of the people watching this know what a trust is, but that's about where the knowledge stops. So it becomes a very easy tool for the out-of-town guru to come in and charge you a bunch of money because they've got the answer, and the answer is a trust. And Garn-St. Germain Act says that they can't call the due on sale clause if you buy subject to and you put it into a trust. It's brilliant. Wrong. Can you talk a little bit about that for us with the trust aspect and due on sale clause and Garn-St. Germain?
Well, let's talk a minute, about Garn-St. Germain. Let's talk a little bit about a pact trust.
If anyone else is lost, I'm right there with you.
We will explain.
Yeah.
Let's talk a little bit about a real trust, an inter vivos trust per se, or like a living will, and or a land trust.
And to set us up properly for those that may not understand, subject to is essentially taking over on payments. We would never say that to our seller. Go watch our other episodes about that. But you're continuing to pay on somebody else's behalf. You get deed, but the property stays in their name. When that happens, when deed transfers from somebody who has a mortgage, there's a clause in that deed of trust that says if you transfer ownership interest, the bank has the option but not the obligation to ask for the remainder of that mortgage to be paid at that point in time.
That's right. So first off, Garn-St. Germain was passed back in either 80 or 81, and it simply said that if a homeowner transfers their property into a financial planning trust, it doesn't violate the due on sale clause. Pretty simple. The problem is people take that and they morph it to mean everything else, and it doesn't. It's all about the intent and things of that nature out there from the conveyance into that trust. Well, then they come along and they create, let's say, a pact trust. So years ago, guys came into Texas with this pact trust thing, which had a multitude of people as the beneficiaries. The seller, the buyer, the investor, everybody was the beneficiary of this with all these various requirements under the pact trust. And guys, it may work, but the problem is if you are the investor trying to explain to a home buyer what the heck you're doing, at that point in time I think you're practicing law without a license, because the great odds are you don't know what you're doing or how it really works. And it gets to be so complicated, you're going to scare your poor buyer off. It wouldn't me. I wouldn't want anything to do with that. Then, of course, we have our traditional legitimate trust, an inter vivos trust or things of this nature that is created, that a homeowner may create or an investor. But that trust is actually, it has a tax ID number, and you get the same protections with that trust as you would with a corporation or an LLC or a limited partnership in that regard. And that's great, but of course no one wants to go to the expense to do that on a trust. So what do? They go back to this thing of a land trust. They're inexpensive to set up and to do the paperwork on it, but a land trust is really nothing more than a DBA. And as Grant said earlier, there were guys out here telling people, just transfer the property into the trust, into a land trust. Do a deed only. That way you have no liability until you get sued because you're not making the payments on the mortgage. And you never gave the poor seller a reasonable mechanism to regain the property in the event the investor fails to make the payments or take care of things appropriately out there. And the last thing you want to do as an investor is bring lawyers into the equation. Because at that point in time, no one wins.
Yeah, lawyers suck.
But the lawyers.
I just want to point out that
Sorry, lawyers out there.
In the real estate investor world, like, you can get creative, you can get fun, you can get crazy, but if something sounds really sexy, take a pause, take a beat, and really dig into it, because chances are it's full of crap or possibly illegal.
Well, the other thing is, so often, it's investors giving investors who give investors
Telephone
advice.
game.
It's a telephone
And by
game.
the time you get to the end, oh my gosh.
Yeah.
You know, and unfortunately, they don't understand it in most cases.
And this is why, I mean, legitimately, if I talk about laws, I have read the law. I've read the Texas State Property Code. I've read Dodd-Frank from start to finish. Like, you have to, the phrase I've always adopted from Scott is trust but verify, okay? You can hear something cool, but go figure it out, right? Or find somebody that is an attorney and consult with them. So one last point on the due on sale thing is, to go back to what Garn St. Germain Act says, Garn St. Germain says if you're transferring this into an estate planning trust, that doesn't violate the due on sale, because they were trying to help those people who were transferring their properties into a trust so that their heirs could receive it in a little bit easier of a mechanism. If that were to ever go to court, your transfer of that property into a trust so that you could buy it without violating due on sale clause is not an estate planning trust, right? That will get broken through just like that. That is not the secure. It might add a veil. And I'll say, the house that I bought for myself to live in, the house that I currently live in right now, is a subject to property that I bought into a trust. It adds a little bit of a veil, but it's not the solution that a lot of people try to act like it is.
What you did, and when we did that deal, because we put that deal together, together for you, was it is a veil. You're creating the veil not only in deed records, which I don't see an issue there. I've always had people ask me, why do you want to do a land trust? Well, I don't want people to know what it is I own.
Right.
And I just kind of go, oh my gosh, guys, I've been doing this 30 years. I've done more deals than,
Shake a stick at.
whatever it might be. I never even think about that. I don't go research what Ryan owns or what Grant owns or anybody. I could care less.
Right.
And most people do too. Even in litigation, they don't care. And if you get sued, they're going to find out anyway. So that's not an issue there at all. But what it does is, in some cases, a land trust is a good mechanism in order to create that veil between you and the bank.
Right.
Because we're not here necessarily to explain to the bankers what type of a trust it is.
Right.
And they rarely ask.
Again, it's not
But it's
an end-all
pierceable.
solution, but it can kind of help. So let's move on to some other questions.
Well, I was going
here.
to say, we need to start flying.
Yeah.
Seems like we need to have Scott in for another grant, teach something.
Yeah, we can.
Because
I'd love to do
I
that.
know Brady had a great. He was like, "Can you walk us through the paperwork
That's a
required?"
huge answer.
That's like 3 episodes.
Yeah. I would love to answer that here, but we just don't have the
Can
time.
you give us a 30, 45-second elevator, the most difficult transaction you ever had to close? Like under a minute, like high level.
Could you not
Do
have
you
called you
understand
this
what you're
earlier?
asking him to do? Yeah, I know.
Before we go there, I just want to make a comment, like with the question that this fellow just asked. I think one of the biggest things I see out in the marketplace really is people not understanding the roles of various people. I get all the time that, well, my RMLO hasn't approved my buyer yet. And it's like, no, the RMLO's role is to gather information, give it to you, the seller, the lender, and you're also the underwriter.
Right.
Too many people think that the
That's a great nugget right there, because I personally don't really have that much experience in the owner finance world, but I would have assumed the RML roles was to approve your buyer.
Nope. They are simply to gather financial information, and that's it.
The RMLO's
provide the rest
job-
of the disclosure.
They provide all the disclosures, and they hand you a package that says, if you choose to move forward with this person, you're going to be compliant. But you have to choose to move forward with that
Got
person.
it.
That's up to you to decide.
That's a huge nugget.
We're the underwriter.
Yeah.
Then, of course, we have our loan servicers, which I kind of call our fraud preventers out there. And I'm glad they're there because it's another necessary evil. I kind of call the RMLOs today the necessary evil because we were forced to use the RMLO because of the compliance issues under Dodd-Frank and the SAFE Act. But the servicer out there also, and too many people take these servicers and they become mailbox money gatherers for them. That's it, hands off. And it's like, no, when you own a property, the servicer's job should be to collect a payment and distribute a payment. And if it's not getting collected, who's going to collect your money better than you?
Yeah.
Relying upon third parties to take the efforts that you want to do just don't work. It is your money. You need to understand it's your asset. Take responsibility for it.
Right.
That's a huge point, and that's another episode. We'll just take notes of episodes we do because the different roles in a transaction and the lifeblood of that house.
I wish
that
I knew
property.
somebody that was opening a good servicing company.
Oh hush, settle pride. Okay, Nathaniel, can you go into more in detail about the one heir who refuses to sign? Like if you got one heir, what do you do?
Only one heir, or you had multiple heirs and one that doesn't sign?
Yeah,
Multiple heirs.
If you got multiple heirs and one doesn't sign, and I have that right now on a deal where I have 80% of the property. And I've been in communication with one heir over and over and over again as to why they should sign. And of course, I'm explaining to them, guys, if you don't do it, here's what I'm going to do. We're going to you're going to force us to file the lawsuit. It's going to cost money. Part of that money is going to come out of your pocket. They're going to appoint a receiver. Realtor fees now come out of your pocket and mine both. And you're going to wind up actually getting less money on this. So you try to take the time to really properly explain to them those kind of items. Sometimes it works, and sometimes it doesn't.
Is that kind of like a subtle strong arm tactic to say, look, I've got most of this in the bag, and you're the only hang up?
Yeah, you do. But the philosophy, the whole saying, forgive me on this one, you can lead a whore to culture, but you can't make her think. It's kind of the same thing. You just can't. You can't change stupidity sometimes.
Is that a golden nugget moment?
That's a skip.
That's awesome. Yeah, no, it's true. It's true. Now, I'm interested to just finish up on that. I'm interested in the process of forcing that sale, right? Because at some point in time, you can force that sale if you have enough of an interest, right? Is there a line? So it kind of relates to that question. Is there a line of demarcation of how much interest?
Nope.
Okay. So it could be two people and you can still force that sale.
Yep.
But you have to get a realtor involved, you have to get the judge involved. What kind of time frame does that look like, and what kind of dollar amount does that look like to get that done? If somebody comes to you,
90
they've got
to
two
150
heirs.
days probably.
Okay.
Depending upon if you can find the heirs or not,
Okay.
the court may have to appoint an attorney ad litem for the unknown heirs.
Interesting, okay.
Which costs more. Now you got two lawyers involved,
Yeah.
and that's worse than one lawyer, obviously.
Is that worse?
It's worse. And just more money
Yeah.
and more time.
So if you gave a roundabout dollar amount for what it might take to force a sale, just roundabout, what are we looking at?
$4,000 to $8,000
Okay.
based upon the situation,
Perfect.
probably.
Perfect.
And again, this is just a knowledge base, and it's a recognition issue. I always try to teach investors how to recognize situations, and I know they don't have the knowledge base how to do it, and that's fine. They don't have to. The key is knowing resources like yourself or us to come to, who can then help to start navigating that transaction down the proper course
Right.
that might be successful.
Yeah.
And sometimes it's hard, and sometimes it's not even doable. But if you don't even know it's an opportunity, then it's 100% not doable, right?
Right. I think that's a great. I love that attitude, right? That attitude of just finding out if it's even a possibility, because either you find out if it's a possibility or you don't try and you know it won't happen.
That's what I love about working with Daniel on deals is like looking at his brain and I'm sure you're
Do
very.
you do that often?
Yeah, well, I mean, just saying because like in the very closed niche blocks of wholesale flip rentals, if it doesn't fit that mold, it doesn't exist. And then when you get outside that box, it's the wild, wild west of real estate where, okay, this strategy didn't work. Okay, this strategy didn't work. Okay, what if we do a blend of these two strategies? Well, that's not working. And you literally just go down the path and you just find a way to make it work through the creative geniuses of the of people like yourselves and Daniel.
Yeah, I think it's awesome. All right, let's hit some more questions. So Brittany points out that Dodd-Frank isn't now TRID, like Dodd-Frank put TRID into place. But yeah, it does suck. It is harder to do traditional QM mortgages, but still, as small creditors, we've got the world at our fingertips.
And a shout out to Scott Carson. Looks like Grant Kemp will subtle plug, be at Note Camp this weekend.
This Saturday at 3:45, I'll be speaking at
I'm
Note
sure,
Camp.
Scott, if you're still watching, drop a link or everybody can click that. We'll be good to go.
The benefits of contract for deed versus wrapping a mortgage. We kind of talked about that earlier in the episode. I'd recommend going through the rewatch and rewinding on that side of things. Use the code Propelio to get $100 off your ticket to the Note Camp. That's pretty sweet.
That's new. Sweet.
Melissa, thank you so much for tuning in. I love talking with you. I like all these big words, learning today.
Look, hey, I'm there with you on these big words. When you see Ryan quiet, it's because Ryan doesn't know what the hell's going on.
Deed in lieu.
Is that Alabama and you coming out?
I'm not, hush.
Deed in lieu as an option instead of contract for deed. I think there's a syntax error there. Am I misunderstanding this? Because I don't think that makes sense.
Let's just touch base briefly.
Okay.
A contract for deed is an equitable conveyance of title. As investors, we can buy a property with a contract for deed. I don't like that because you're keeping that seller in play who may have financial issues, and I don't want that seller to go out and get a judgment lien against them that would attach to that property and could affect me immediately. So I don't like buying homes with a contract for deed for that purpose unless there's a really good reason for it. I will never sell a home to an owner-occupant with a contract for deed. However, I would sell a home to an investor with a contract for deed, because then it helps to kind of level a playing field a little bit in that instance. Now, a deed in lieu of foreclosure is when there is an existing mortgage on a property that is in default. Instead of going out and having to foreclose on the property and go to Armageddon, that is more of a kinder, gentler way of doing things. Is where the borrower deeds the house back to the
seller.
the mortgage holder in that instance, and the mortgage holder accepts the property most of the time in release of their mortgage obligation. And maybe they sign some little note or something where they will agree to pay some arrearages over time. One point that's really important about deed in lieu, because I see this all the time from investors where they fail to check title. Because if that borrower had an IRS lien and you took that deed in lieu and recorded it, you just bought that IRS lien because it attaches to the property. And you don't want that to happen. And so you got to be smart. And most of the time we can do that, and it is a more kinder, more gentler way of handling things, which is what we like so much about the creative finance world. You don't have to have the big bank mentality of no pay, no stay, and no options. But you need to make sure you navigate things properly and have an understanding of how to do things correctly.
So let's hit a couple more and then do a hard stop so Mr. Grant can get to his appointments.
Yeah,
and,
forgive me. I have a
and
seller
also-
appointment that I have to get to right after this. So we
And
got a
I
hard
only
stop.
had
You need to make money.
$3,000, so I couldn't get Scott to stay longer. Per Dodd-Frank, this is for
Araldo.
How do you say
Araldo.
it? Araldo. Per Dodd-Frank, can investors service their own notes? I thought we had to use a licensed servicer.
There is no legal requirement that I am aware of, at least here in Texas, that
Right.
requires a third-party servicer to be incorporated into a transaction.
And Brittany points out, she says for QM loans, you must have a licensed servicer. And I would really encourage, Brittany, can you point me to the place in the law that says that? Because
And QM stands for?
qualified mortgage.
Thank you.
Because that was not true to the last of my knowledge.
I have not heard
so
that
unless there's
anywhere.
been an amendment that came out that I just missed somehow, you do not have to use a license. Now Brittany comes from the traditional mortgage world, right?
She was in title. She was the
Okay.
title beast for a while,
Okay.
and now she's been in mortgaging notes conventional
Okay.
for the past 6-8 months.
So Brittany, one of
She's
the
taken
things that will
over.
be very valuable to you to learn over this period, getting into this side of the things, is that small creditors and small servicers the world is opened up to us. Small servicing, I can't remember what the qualification is for. Oh yes, I do. It's under 5,000 notes that you service. If you're a small servicer, it's similar to like small creditor versus big predator. You're used to the traditional world, which has to, what most people that are coming from the traditional world, and this is not just for Brittany, this is everybody. Most people coming from the traditional mortgage world don't realize that a lot of the things that you think are regulation are actually just underwriting rules of the company you worked for. Because I hear that all the time. They've got their own servicing, their own underwriting laws, their own blah, blah, blahs, but it's not actually from Dodd-Frank. It's not actually from RESPA. It's not actually from SAFE Act. It's something that was put in by your company. So as a small creditor and a small servicer, I am going to go out and say, no, you do not need to have a licensed servicer. I would like to say that you do because I'm opening a servicing company, but unless you can point me to the place in the law, I'd like to see that.
Let me make one quick comment too about servicers and whatnot. Prior to 2008, 2009, loan servicers for seller finance transactions really didn't exist at all. And the reason we kind of brought them into the play and set them up for this reason was when you're talking to a real estate broker and people who have limited knowledge on the seller finance business, one of the first things that you get the pushback is, well, I can just see that investor selling the home to a home buyer, getting this big down payment, collecting payments, and never making their mortgage payment. And then the property winds up getting foreclosed upon because the investor committed fraud on the owner occupant, because that's happened many, many, many times, obviously. The way you get around that and you cut it off at the knees real fast is you incorporate that third-party loan servicer. Now, when there's an independent party exclusive of the investor out there, it becomes the fraud preventer, is what it is. Now the only person who can complain that the mortgage is not getting paid is the actual homeowner or the borrower who didn't make the payment to the loan servicer. And it simply is a way to eliminate, the issue out there.
It's a good negotiating point when you're acquiring properties or selling properties.
Let's hit one more question just because we can hit it real quick, and then after that we'll wrap up. And then what I'll do is I'll make sure we commit to answering all the questions that are beyond this. So keep the questions coming, whether it be today, 6 months from now, we'll still do
And
this.
we'll see if we can get Scott. Scott, would you be willing to come back out at some point in time and maybe finish up some of these? Because we got questions rolling in. I'm putting him on the spot in front of camera.
So this is an easy question. Jessica was saying, and Jessica's fairly new. I think she's been doing this 6-8 months. Typically, why does the seller refuse to sign?
Like one of the heirs.
Yeah, and from my point of view, it's the same negotiating tactic if it was just a one-off seller. There's no telling.
I have a situation where one of the sellers didn't want to sign just because they were mad at the other heirs.
Mad at the other heirs. They're not enough money. They have sentimental value to the house. So it's just, there is no set stone.
Nope.
It's just the same answers of everything else.
The key to all of these types of questions along those lines is it's like we all, I'm going to make a very out there analogy. If you're cooking, you might have sugar, yeast, and whatever,
Chocolate.
salt. And you can make 20 different things out of that.
Whatever.
If the question came in of like, you're looking at a loaf of bread and you're trying to dissect that loaf of bread, well, that loaf of bread is made up of many different things that can be used for many different things.
Right.
The key here is we want to learn the salt, the sugar, and the yeast so that we can apply that to different
Yeah.
scenarios. Was that out there enough?
Where did the chocolate
Did I
go
smoke
away?
enough before I came in?
I would
to
just say on that,
It's like-
that when you're dealing with all those heirs, is go back to head, heart, gut, and realize each individual heir is its own negotiating tactic.
I'll make this comment. I see so many, I'm just going to put the word out there, wholesalers,
Yeah.
and these young guys who don't understand that they go and they will contract with one heir, get a contract signed for the full price of the property. Now, of course, to have a valid contract, they have to have the probate work done or heirship affidavits done prior to, so they have capacity to sign. But then you probably need all these other signatures
Right.
before you have a valid sale. Well, the problem is that young investor just contracted to buy the interest of that one heir for full price.
Yeah. Yeah.
And it's a knowledge base.
Yeah.
There's another
that
golden nugget for you.
They simply don't understand. And I see that over. And then they go file the contracts and memorandum of contract and deed records. And it's just like, y'all can't do it.
Yeah.
So-
hey everybody, this one heir gets the full process. So Scott, thank you so much for joining
Yeah.
us today. How can people get in touch with you to get your actual legal work done? Because remember, Scott does title, he does legal, and he also is an
Deals.
investor. He'll do deals with, won't you JV with people if they've got a deal? Is that something that I want to throw out there for you? Or
I mean, we are, Grant, and thank you for asking. I mean, we're real estate and title attorneys. We don't go out and we don't do everything in the law practice. We work with investors, we work with realtors. We do a huge volume of the seller finance business out there. We do landlord tenant representation, those kind of things. Things that directly affect our real estate investment community is what we like to work on out there.
so how could somebody get in touch with you guys?
So getting back to that point, our website is Horne and Associates PC. My email is Scott@Horne, that's Horne, guys, and Associates PC, or excuse me,
I was about to say
it's
HorneRealEstateLaw.com.
HorneRealEstateLaw.com.
We'll drop links we'll find out what his website's.
And our office number is 972-271-1700.
Excellent.
That's awesome.
But we're just here to help the real estate investment community, whether it's in the legal side or title side in that regard. We understand this business. That's
Better
the key.
than anybody.
We are here to help investors, not necessarily on every little problem they've got out there. We try to help acquire more houses for them, and whatever that might be. We do partner with the right investor, not everybody, on the right transactions. We have that ability to do that. You know, whether it's Ryan or Grant or whomever. And it's about providing a service and being a resource for our investment community here in the DFW and North Texas area.
I was going to say, if the audience wants more Scott, please drop in the comments. We want more Scott.
We can bring him
and
back out.
we can make that happen.
Jessica asked the question, mentor, and I want to. This is an awesome time to answer this question because you know, Scott was my mentor in the business, and not in so many words. And it wasn't through he ran a 3-day event and I paid $60,000 kind of thing. But ultimately, through our partnership and as we grew together, he was the foundation that I was able to stand on to get to the position that I am today, and I'm ever so thankful for that. If you are looking for mentoring, CreativeCashFlow.com, I do personal mentoring. I do training online. That is what I'm about, is the training and trying to get you to that next level. My whole model and drive is to help you buy more houses. So if you're looking for mentorship, reach out to me, CreativeCashFlow.com. You can hit me in the comments. Look at CreativeCashFlow.com. We got a lot of modules, got a lot of exclusive videos that are available for you there to learn how to do all these creative strategies and get far into that side of things as well.
Both of y'all are big on speaking. Any speaking gigs coming up anytime soon?
I think it's January the 10th, North Texas RIA. We're doing a 1-day on seller financing, more of the nuts and bolts of it.
That's like way far away.
Yeah, that's the soonest one I got coming on.
Yeah.
Mr. Kemp?
I'll be speaking at Scott Carson's Note Camp this weekend. Remember, he said drop Propelio as your discount code. You get $100 off the ticket. I'll be speaking at 3:45 on Saturday or 3:30, something like that.
As far as Propelio.com, if you're looking for access to true MLS comps, if you're looking for off-market lead lists, and if you're looking for, what else we got? Investor-friendly websites, check out Propelio.com. Also, make sure you're subscribed to our YouTube, our Facebooks, and our podcast with the notifications on, because we got a lot of exciting things coming in 2019 that we're in the works. Thank you for everybody that came out to the event last night. It was a great event. All the events we've thrown in 2018, we've had a great turnout, and we're very thankful for everybody being a part of it.
I love the culture and the community that's being built here. So thank you guys for being a part.
Stay positive, stay happy, and do some deals and conquer your shit. I don't know.
Is that your next
I'm trying to get I'm trying to get a saying. Conquer. I don't know. I got nothing. Anyway, Scott, Grant, thanks as always.
Thank you.
And we'll see you next time.